Taiwan elections, political repression masquerading as the rule of law. Human rights practices in Taiwan.
In regard to Taiwan, the most recent Country Report on Human Rights Practices by the U.S. State Department Bureau of Democracy, Human Rights, and Labor mentions the word Constitution 12 times, but does not discuss the issue of how the ROC Constitution came to be regarded as the organic law of Taiwan. The U.S. State Department apparently has not considered that, in truth, elections in Taiwan are only held under a superficial facade of democracy and are not truly representative of the hopes, the will, and the desires of the Taiwanese people. Let us not forget some facts which are not mentioned on any governmental websites in Taiwan. Namely, that the ROC Constitution was not drafted based on any deliberations or negotiations by locally selected Taiwanese delegates. It was promulgated at the point of a gun by the KMT-led ROC government during a period of violent political suppression which had begun in late February 1947. Most significant, perhaps, is to realize that putting the ROC Constitution into effect in Taiwan was based on the false premise of October 25, 1945 being Taiwan Retrocession Day.
However, in the annual Human Rights Practices reports, the U.S. State Department Bureau of Democracy, Human Rights, and Labor does not concern itself with such matters. Their research for writing those reports apparently only goes back to the early 1990s. Of course, some people would say that the native Taiwanese people have already lived under the Republic of China Constitution for nearly 70 years, and they are accustomed to it and enjoy the campaigning activities and many levels of elections which are regularly held under the Constitution's overreaching authority. If this is truly the case, there is a simple solution. Not including the title, the words Republic of China appear in the ROC Constitution 18 times, and the word Chinese appears 7 times. These could be changed to Taiwan Territory and Taiwanese respectively. This correctly amended constitution could then be continued in force temporarily until a new Taiwan constitution could be drafted.
As mentioned above, in the post-war San Francisco Peace Treaty of April 28, 1952, the territorial sovereignty of Taiwan was not awarded to China. Hence, there is no legal basis for the use of the Republic of China Constitution in Taiwan. The promulgation of a new legal code for Taiwan, as was done in 1947, during a period of belligerent occupation, is a war crime. Based on the above listing of war crimes, it should be easy to see why Taiwan, or the Republic of China on Taiwan, cannot be regarded as a sovereign state. Some people would argue that the ROC on Taiwan meets all of the Montevideo Convention's criteria for statehood. However, in fact, all of its qualifying criteria are bogus. It exercises effective territorial control over Formosa and the Pescadores, but there has been no official transfer of title. The native Taiwanese population was mass naturalized as ROC citizens in 1946, based on the false premise of Taiwan Retrocession Day and in direct violation of the Hague Convention's stipulations regarding the treatment of the populace of occupied territory. It has a government, but it's a government in exile, etc.
The disposition of Taiwan under the SFPT. But how can we understand the correct international legal position of Taiwan territory? As we know, Japan renounced its sovereignty over Taiwan in the treaty. So, how can we make a determination of what the treaty intended as the final disposition of Taiwan? With reference to the laws of war, we can see that the treaty did not specify any final disposition, but it did specify a temporary disposition. In Article 4B, Taiwan was placed under the jurisdiction of the U.S. federal agency, the United States Military Government, USMG. Many people argue about how to interpret the meaning of Article 4B, but such an argument is easily settled by examining what actions the United States took in the ROC Islands.
Yes, this same article that gave USMG jurisdiction over the ROC Island Group also gave USMG jurisdiction over Taiwan. Hence, after reading the SFPT, our first impression would be that elections in Taiwan territory should be held under the jurisdiction of the USMG. That would mean that a U.S. military governor should be appointed, the U.S. flag should be flying, and local inhabitants should be enjoying fundamental rights under the U.S. Constitution, similar to the inhabitants of other U.S. overseas territories. The U.S. military governor would then announce procedures for selecting delegates to a local Taiwanese constitutional convention, and the Constitution of Taiwan territory would be drafted. Of course, this should have been done in 1952, if not earlier. However, it is still not too late to take the necessary remedial actions to deal with these matters.
Which U.S. government agency should do this? Still being under the USMG, Taiwan does not fall under the jurisdiction of the U.S. Department of the Interior. Clearly, it is the responsibility of the U.S. Department of Defense to deal with Taiwan's legal reorganization issues. Does this mean that Taiwan would become an independent nation, or the 51st state in the USA? The answer to these questions is no. Under the specifications of the SFPT, Taiwan is correctly regarded as a quasi-USA trusteeship under military government within the U.S. insular law framework. Trade relations with the USA would be coordinated based on an insular trade agreement or similar free trade arrangement.
In summary, elections in Taiwan should be held under the mandate of a new Taiwan Constitution, drafted under the overall administrative authority of the United States of America. By following the specifications of the SFPT to regularize Taiwan's legal status, it would then be fully fitting and proper that the Republic of China officialdom be allocated some land area in a corner of the island to conduct their own affairs, until such time as they could return to their beloved homeland of mainland China. As exiles, it would not be expected that they would have voting rights in local Taiwan elections.
In conclusion, looking at the record from the early 1940s to the present, much significant legal evidence can be assembled to show that the local Taiwanese people are being held hostage by the ROC regime and forced to live under the ROC legal framework, in direct violation of international laws and treaties. Elections in Taiwan are based on the constitutional framework of a country that does not exist, and the inhabitants of Taiwan are trapped in political purgatory. That the international media is not taking notice of this entire situation is quite surprising as well. A series of in-depth articles on the Taiwan session scandal should have an excellent chance of winning the author a Pulitzer Prize. The Truth of October 25, 1945.